10 seconds. That's how long it took a Tupelo, Mississippi police officer to go hands-on with a man filming a building from public property.
My owners called me because they saw you in the security camera. Just want to know what was up.
Really?
Just wondering why you're videoing us.
Wondering why I'm videoing?
Yeah.
Well, let me ask you a question. Do you support the Constitution?
Absolutely.
All right. So I exercise and
I understand
stress
that,
test the First
but it's
Amendment.
weird.
No, you just told me you didn't understand it.
I do, but it's weird, and you're taping people.
It has to have doctor's appointments and
This is
doctors
HIPAA
and patients
required.
have
That's
their
what I'm
privacy
telling you.
Oh, it's HIPAA required?
HIPAA related.
Can you tell me what HIPAA stands for?
Yes, I can.
Go ahead. What is it?
But he won't even come here and he's a paid.
I'm calling you off.
What you out here doing, man?
What am I doing?
Yeah, come over here and talk to me. Come over here and talk to me.
Whoa! Why are you going to touch me? What's going on?
Come over here and talk. You are on private property.
I'm not going to go.
You are on private property.
Okay.
Do not tell me what you're not going to do.
All right.
Why are you out
illegal
here?
Search and seizure.
Why are you out here?
I'm invoking my Fifth Amendment rights, sir.
And when they booked him, they charged him under Senate bills that died in committee, statutes that literally didn't exist. I'm Brandon Grable, civil rights attorney, and this is Clearly Established. This footage comes from First Amendment Protection Agency, linked to his channel in the description if you're not already familiar with him. January 2026, First Amendment Protection Agency is filming the exterior of a cannabis dispensary in Tupelo, Mississippi.
Today we're here in Tupelo, Mississippi, and we're going to be going around and doing our regular thing, stress testing the First Amendment right to record in public, seeing how the public and or the public officials act if they do arrive out here today. So as usual, thank you for being here and stick around. Today we have the Dabs Cannabis Dispensary here in Tupelo, Mississippi. We're on a pretty busy road right here, right next to North Mississippi Medical Center, so we should have a busy day here today.
He's standing on what GIS records confirm is public property, the public right-of-way. And then things escalate. A man in a truck pulls up.
Let me take that damn thing away from you, stomp it and goddamn break it up. You better get your ass out of here. You don't belong here. The damn law's on the way to run your ass off anyway.
All right.
Well, go then. Won't you go before they get here and get you then?
No.
Oh, you want to go to jail then, do you?
Someone calls police and Officer Douglas Dean responds.
You're being arrested for criminal loitering.
Criminal loitering. Sounds good.
You can't give me a reason why you're out here.
Criminal loitering. Under Senate bills from 2024 and 2025, both died in committee, meaning neither is law.
What you got?
All of that stuff he's got on that phone of me, I want it took off. That's invasion of my privacy.
He's got a right to video. He's got a right to video.
This officer, after arresting this man for filming, tells an angry bystander that he had a right to film. That's not a mistake, that's an admission. Now let me show you how this is supposed to work.
Something wrong with you?
Is everything all right?
Why will you ask?
Are you okay?
What make you ask that?
You're standing on the side of the road.
Oh, not normal?
May I ask for recording our customers coming in and out?
Because I got a camera. I see that you got cameras and I'm not uncomfortable.
Yeah, we have cameras pointing inside. That way we can record anything that happens inside.
So the customers are uncomfortable.
Yes. I've already had multiple reports of people inside telling me there's a man across the street recording them.
Should I go get them like a teddy bear to make them feel better?
No, I think you should just go home and stop whatever kind of protest you're doing at the moment.
I'm protesting?
We're going to call the cops in a minute.
No, don't do that because I got warranties, man.
I understand. We're going to call the cops regardless.
Don't do that, bro.
We already did.
Please don't do that, bro.
We already called the cops. So
They're
if you have a
gonna,
warrant
they maybe
on you,
kill me.
that's your problem, not mine. So you
So
go home
if they're
and
gonna
not get
come,
killed.
I don't have no
We're
weapons
going
or
to call the
anything.
cops. So
Please don't.
We're calling the cops.
Don't do that, man. I'm gonna have to take off running then.
Please do.
As you see, we're in the right of way. This is where everybody walks through here. You see, family? And you see here, they go to city light poles. Welcome to hometown. I'm on this side. The GIS perfectly says so. Name and batch number.
Pardon me?
Name and batch number.
Corporal Tato, star number 111. How are you today?
Name and batch number.
Officer Palmer, badge number is 146.
Is your camera on?
Yeah.
It's your camera on.
It is. Red light's right there.
Thank you. Well, how can I help you?
They just called that somebody was causing a disturbance. We're just coming to see what's going on.
You didn't see no disturbance here, right?
I didn't say I saw the disturbance. I said they called.
But when you arrived here, did you observe a
That's
disturbance?
not the point. We have to come anyway.
You're doing an investigation, right?
Regardless. Is there a disturbance or not a disturbance?
Do you see any disturbance here?
Was there a disturbance?
I didn't call you. I'm just standing here with a camera. That's all I've been doing. Everything's on camera, just like your camera, brother.
That's your absolute constitutional right.
And a GIS right away.
Oh, you're on public property. I never.
Public property,
mentioned
sir.
One thing about that, did I?
And when you arrived here, what was I doing?
Standing right here, video recording.
No disturbance.
No issue.
Same way I've been here.
So you asked my name, Corporal Toto, hometown police.
Corporal Toto,
Star
my
number
man.
111.
My man, 111, man. You're keeping it professional.
You got rights, brother. I'm not here to violate your rights.
That's it, man.
We're just here to respond to a call. You're on the public way. So that's what you understand. When we get the call, we have to go based on what we first
And you
hear.
got to investigate,
Right.
you know?
And bro, you're on public property, First Amendment.
Yeah, there you go, brother. There you go.
Me.
We just educating people, man.
So what I'm gonna do is I'm gonna leave you for a second. I'll follow up before I leave. If you want to talk, I'm gonna go speak to them and let them know.
If you educate them, that's fine with me,
no,
brother.
That's what I'm gonna go do.
If
So
you,
I have a newer officer with me.
Officer Toto.
Yeah,
If
so I have
you-
a newer officer. I just want to make sure that
get
we're
him on
doing the right
training,
thing,
man,
right?
before he escalate.
That's why I want to make sure.
All right, Toto, man, you're doing the right thing, brother.
So here's what I told you. I said that where you're standing, you can't do nothing. You can film all you want, anything that I can see with my eyes.
That's right.
There's no expectation of privacy in public.
Woo!
Whatever I can see with my eyes, I can video record.
You better learn from him.
That was explained to him, and you're
my man, Toto, brother,
right.
man.
That's
You know
all.
what? I got a little sweat in my hands
What's your
from
name,
holding.
man?
They call me Jay, man.
Jay, I'm Chris.
Jay, Chris, my man, bro. Palmer, man, you have a blessed day, brother, man.
Just be safe. I just don't want to get hit by a car.
You know what, man? We start looking at police officers totally different.
Same scenario, different state. This footage is from Yaya 2 Audits, also linked in the description. Same activity, same type of business. One officer investigated, verified the person's rights, educated the complaining parties, and used it as a training moment. The other went hands-on in 10 seconds and arrested a man for exercising his constitutional right that he acknowledged on camera. Quick thing. YouTube tells me that about 85% of you watching right now aren't subscribed. If you care about civil rights, police accountability, and understanding the law that actually protects you, hit subscribe. It's free, it helps the channel, and you might learn something that matters when it counts. All right, let's get back to it.
The charges changed. No longer dealing with criminal loitering. We're dealing with disruption of a business and disorderly conduct. Now, those are two of the same charges, essentially, because it's a subsection of disrupting a business is a subsection of disorderly conduct.
So let's talk about why these charges should be dismissed. Because under Mississippi law, this man didn't commit a crime. Remember those Senate bills that the officer cited? SB 2330, the criminal loitering bill? Well, it died in committee in February of 2025, which means it never became law. And here's the thing, even if it had passed, that bill required 48 hours written notice before enforcement. You can't arrest someone under a statute that doesn't exist. In Toledo's local ordinances, I checked those too. There's nothing. No city ordinance prohibits filming from the public right-of-way. The only loitering provision in Toledo's code applies specifically to airports, or the airport, and this isn't an airport. So what did they actually charge him with at arraignment? Well, it sounds like the first charge was disruption of a business under Section 9735(5), and this statute requires the person to be in or on the premises of another. And here, GIS confirms he was on public property. The statute's threshold requirement isn't met, so the charges fail as a matter of law. And the second charge, disorderly conduct under Section 9735(7). This is Mississippi's failure to comply statute. But it requires the officer's order be given to avoid a breach of peace. And it requires the person have an opportunity to comply. Here, obviously, is being told to come onto private property. And Mississippi courts have been clear on this. In Mastin v. State 2015, the Court of Appeals reversed a disorderly conviction after finding there was absolutely no evidence the officer ever ordered the defendant to leave. But here's the case that really matters. Collins v. State in 2017. A woman called a state trooper a racist motherfucker during a traffic stop. She was arrested for disturbing the peace, disorderly conduct, and public profanity. The Court of Appeals reversed every charge except speeding. The court quoted this principle: the freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. That's from City of Houston v. Hill, Supreme Court case. And so in Mississippi and elsewhere, you can curse a cop, and that's not enough for disorderly conduct. But this man got arrested for silent filming. And the hostile bystanders, the truck guy threatening to stomp the camera, under Wright v. Georgia 1963, the Supreme Court held that the possibility of disorder by others cannot justify arresting a person exercising constitutional rights. The heckler doesn't get a veto. This brings us to the constitutional claims, because if or when this guy sues under Section 1983, he has strong argument. Let's start with the First Amendment. In 2017, the Fifth Circuit, that's the federal circuit covering Mississippi, decided Turner v. Driver. The court held that the First Amendment right to record in public is clearly established. That was 8 years ago. Officers in Mississippi have been on notice ever since. And then you have the Fourth Amendment. An arrest requires probable cause. Here, the initial charges were based on statutes that didn't even exist. And the replacement charges, well, they require elements as well that just aren't present. The officer acknowledged the activity he was engaged in was protected, so there isn't any probable cause. Now let's talk about qualified immunity. If you're not familiar, here's what you need to know. When a police officer violates your constitutional rights, you can sue them personally under a law that's called Section 1983. But there is a catch. Courts created something called qualified immunity, which shields officers from being sued unless they violated a right that was clearly established at the time. So what does clearly established mean? Basically, there has to be a prior court decision that puts the officer on notice that what they did was unconstitutional. If no court has ruled on that exact situation before, the officer can walk, even if what they did was obviously wrong. So the question isn't just, did he violate the Constitution? It's, should he have known he was violating the Constitution? In here, the answer is yes, for reasons. Reason one, the right is clearly established.
He's got a right to video.
As discussed, Turner v. Driver has been the law for 8 years. Reason two, the officer knew this right existed. He said so on camera. You cannot claim you didn't know the law when you articulated the law. Reason three, the obvious clarity standard. In Hope v. Pelzer, the Supreme Court held that officials who commit patently obvious constitutional violations don't get qualified immunity. Judge James Ho of the Fifth Circuit applies this in Villarreal v. City of Laredo. In 2022, writing for the court, he said, it should be patently obvious to any reasonable officer that the conduct alleged constitutes a blatant violation of constitutional rights. Reason four, this wasn't a split-second decision. The Supreme Court just addressed this last June in Gonzalez v. Trevino. Anomalous procedures and unusual arrest circumstances can be evidence of retaliation, not legitimate law enforcement. And I'll tell you, I know this area of law. I've litigated, I'm sure you've heard of it, Zenter v. Salvaggio, the Leon Valley case involving First Amendment auditors, rounded up by a now twice-fired police chief because he was offended by their recording.
First of all, thank you for coming to Leon Valley. Totally support your right. Put something on to your First Amendment right. What you don't have a right to do is be streaming things where police officers or anybody else's family is being threatened or violation of the state law. If you're not from Texas, that's your problem. You should have known better. So if you stream something, you are responsible for its contents. There's death threats on y'all's YouTube Live, and every one of y'all will be held accountable for those death threats. Does everybody here understand what I'm telling you? So, bottom line,
ACLU.
Let's go. You're under arrest as well. Move.
Under arrest.
Get up here.
Even though we cannot be held responsible.
For a civil, now constitutional felony.
He's calling it a felony. We're taking these people to jail.
Okay.
Just so you know, this is the only camera I have. It does not stream live. It's a static camera.
So everybody else, you're not free to leave. Come on across the street.
We're detained. We're all detained.
Get on over here, sir, right now. Every one of y'all are witnesses to the crime. Every one of y'all, your cameras, your devices.
They're going to illegally seize our property.
Sit down right here.
We're all being arrested.
Right here. Every one of y'all.
And in that case, the federal court held that by 2018, the right to film police without retaliation was clearly established, and the false arrest claims survived summary judgment. The law is clear. It's been clear for years. This junior cop, he's on notice. This police department's mission statement reads, to protect all people within the boundaries of the city of Tupelo and uphold the Constitution of the state of Mississippi and the United States of America. It looks like Officer Dean, if I'm reading this right, graduated from the police academy in March 2025. If true, he's been an officer for less than a year. A rookie officer arrested a man for exercising a constitutional right, a right the officer acknowledged, and he charged him under statutes that don't exist. And when that failed, the prosecutors, rather than upholding the law, substituted those charges that don't fit the facts. Meanwhile, in Illinois, Corporal Tato did everything right. He investigated, he verified the auditor's rights, he educated the public, and he trained his newer officer. That's the difference between constitutional policing and a federal civil rights case. Under Mississippi law, these charges should be dismissed. Under Fifth Circuit precedent, qualified immunity should not protect this officer. The First Amendment means nothing if you can be arrested for exercising it by an officer who admits you have that right. This is clearly established. Thanks for watching.